Thank you for joining us and welcome to class. Today we are looking at Gatley and we're looking at pre-trial applications. So let's see. Introduction. Generally, this chapter attempts to deal with the principal interlocutory matters which arise in the course of defamation litigation. The great majority of actions settle before trial, and defamation remains a field in which a sound grasp of interlocutory tactics is frequently of crucial importance in determining the outcome. Whether by forcing a favorable settlement before trial or by ensuring that if trial comes, the litigant's case is thoroughly prepared and his opponents properly understood. Rulings on meaning. The jurisdiction to obtain a ruling on whether or not words are capable of bearing a particular meaning, whether they are capable of bearing defamatory of the claimant, and whether they are capable of bearing any other meaning defamatory of the claimant has proved extremely valuable. The whole purpose of the new rule is to enable the court to fix in advance the ground rules on permissible meaning, which are of such cardinal importance in defamation actions, not only for the purpose of assessing the degree of injury to the plaintiff's reputation, but also for the purpose of evaluating any defense raised, in particular justification or fair comment. This applies with particular force where there is a defense of justification of a lesser meaning than that pleaded in the statement of claim. Background. Okay, so you can seek a ruling on meaning. Okay, until 1991, the court could only be asked to rule whether words were capable of bearing a particular pleaded meaning, which is a question of law for the judge at the trial of the action. If a party wished to attack his opponent's pleading meaning, whether it was the meaning put on the words complained of in the statement of claim or the Lucas box meaning summarizing what the defendant sought to justify, he could only do so by invoking the jurisdiction on the RSC or Ordinance 18, Rule 19, which entailed arguing that the meaning was one which the words were not even arguably capable of bearing. It was not until 1991 that it was established that there was a jurisdiction under RSC Ordinary 3 R3 to try as a preliminary issue to question whether the words complained of were capable of bearing a particular meaning, but there was still a clear need for a simplified procedure. This was finally provided in 1994 by RSC Ordinance 82 R3A, which became CPR PD 53, paragraph 4.1. Conceptual problem. The underlying intellectual tensions of the exercise of determining meaning were well expressed by Diplock LG. Everyone outside a court of law recognizes that words are imprecise instruments for communicating the thoughts of one man to another. The same words may be understood by one man in a different meaning from that in which they are understood by another, and both meanings may be different from that which the author of the words intended to convey. But the notion that the same words should bear different meanings to different men and that more than one meaning should be right conflicts with the whole training of a lawyer. Words are the tools of his trade. He uses them to define legal rights and duties. They do not achieve that purpose unless there can be attributed to them a single meaning as a right meaning. And so the argument between lawyers as to the meaning of words starts with the unexpressed major premise that any particular combination of words has one meaning which is not necessarily the same as that intended by him who published them or understood by any of those who read them, but is capable of ascertainment as being the right meaning by the adjudicator to whom the law confides the responsibility of determining it. Principles to be applied. Nonetheless, the rules for determining whether words are capable of bearing a particular meaning are well established and rarely controversial. The starting point is that the judge's function is to delimit the range of meanings of which the words are capable and to rule out any meanings outside that range. The judge's role is to decide what meaning within that permissible range the words actually bear. A helpful formulation of the principles was constructed by EDJ in Gillick versus Brook Advisory Center, described by Lord Phillips MR on appeal as an impeccable synthesis of the authorities. The proper rule for the judge when adjudicating a question of this kind is to evaluate the words complained of and to delimit the range of meaning of which the words are reasonably capable, exercising his or her own judgment in the light of the principles laid down in the authorities and without any of the former Order 18, Rule 19 overtones. If the judge decides that any pleaded meaning falls outside the permissible range, then it will be his duty to rule accordingly. In deciding whether words are capable of conveying a defamatory meaning, the court should reject those meanings which can only emerge as the produce of some strained or forced or utterly unreasonable interpretation. The purpose of the new rule is to enable the court to fix in advance the ground rules and permissible meanings which are of cardinal importance in defamation actions, not only for the purpose of assessing the degree of injury to the claimant's reputation, but also for the purpose of evaluating any defense raised, in particular, justification and fair comment. The court should give the article the natural and ordinary meaning which it would have conveyed to the ordinary reasonable reader. Reading the article 1. Hypothetical reasonable readers should not be treated as either naive or unduly suspicious. They should be treated as being capable of reading between the lines and engaging in some loose thinking, but not as being avid for scandal. The court should avoid an over-elaborate analysis of the article because an ordinary reader would not analyze the article as a lawyer or accountant would analyze documents or accounts. Judges should have regard to the impression the article has made upon themselves in considering what impact it would have made on the hypothetical reasonable reader. The court should certainly not take a too literal approach to its task. Finally, the words complained of must be read in context and being taken with any surrounding antidote. Chase levels of meaning. Forensic consideration of the meaning of words has acquired a new shorthand since the impact of the decision of the Court of Appeal in Bennett versus News Group Newspapers Limited and Chase versus News Group Newspapers Limited, which have introduced the language of level or tier 1, 2, and 3 meanings into legal debate. In very broad terms, they may be understood as meanings which impute 1, guilt, 2, reasonable grounds to suspect the claimant of guilt, and 3, grounds to investigate the claimant. As Sedley LJ pointed out in a more recent case, the elevation of this taxonomy of meanings into legal categories is recent. It is correct to say that as long ago as 1963, in Lewis versus Daily Telegraph Limited, 1964, AC 234, a libel action arising out of an article headlined Fraud Squad Probe Firm, it was recognized, at least by Lord Devlin, that such an allegation might operate on any of 3 levels, each distinctly capable of justification. The fact of an inquiry, the existence of reasonable grounds for suspicion, and guilt. But although the practice criticized by Lord Devlin, Loc. Cite 287, has persisted of letting a claimant plead only his highest meaning and then argue for any lesser one. It was not until the decision of this court in Bennett versus News Group newspapers that recognition was accorded to these three clauses as being legally distinct. More recently, there has been a recognition that more than three levels of meaning may be required. For example, Gray J has observed that there is a considerable gulf between the imputation of guilt of a criminal offense, level 1, and the imputation of the existence of ground, even reasonable ground, for suspicion of guilt, because the degree of reasonable suspicion may vary greatly from case to case, and in one case he found, on the hearing of a preliminary issue, that the true meaning was somewhere in between cogent grounds to suspect. Jargon apart, the underlying principles have not changed, and indeed, the skews and Gillick formulations have been repeatedly followed and endorsed. The high threshold for exclusion of meaning. However, the Court of Appeal has given a strong indication that first instance judges should be slow to rule out pleaded meaning, particularly at the level 2, level 3 divide. In Jamil versus Wall Street Journal, the point was approached from two different directions. Firstly, at 10, Simon Brown LG advised judges to bear in mind the observations of Lord Nichols on the imprecision of language in Bonnick versus Morris. Language is inherently imprecise. Words and phrases and sentences take their color from their context. The context often permits a range of meaning, varying from the obvious to the implausible. Different readers may very well form different views on the meaning to be given to the language under consideration. That, of course, is one of the reasons why EDJ was reluctant in Armstrong versus Times newspapers to allow a preliminary issue of meaning to be tried by a jury. He was troubled by the prospect of the jury drafting in committee, each member contributing his or her own views to produce a special verdict. The same judge observed in Fallon versus MGN Limited that the chase levels of meaning may be a somewhat artificial scale in the sense that defamatory words are capable of hearing an infinite variety of meanings and implications, and correspondingly a range of levels of gravity which do not necessarily lead themselves to classification in one or other of these three categories. Secondly, at 14, Simon Brown LJ emphasized the high threshold of exclusion which must be satisfied every time a meaning is shut out, including any holding that the words complained of either are or are not capable of bearing a defamatory meaning. It must be remembered that the judge is taking it upon himself to rule in effect that any jury would be perverse to take a different view of the question. It is a high threshold of exclusion. Ever since Fox's Act 1792, the meaning of words in civil as well as criminal final libel proceedings has been constitutionally a matter for the jury. The judge's function is no more and no less than to preempt perversity, that being clearly the position with agreed to whether that being clearly the position with regard to whether or not words are capable of being understood as defamatory or, as the case may be, not defamatory. I see no basis on which it could sensibly be otherwise with regard to differing levels of defamatory meaning. meaning and the repetition rule. Sorry, we are in Jamil versus Wall Street Journal. Simon Brown referred to the scope for the border between the levels to become blurred, and in Jamil versus Times Newspapers Limited, Sedley LJ observed in differing from Gary J, who had ruled out a level 2 meaning that the distinction between level 2 and level 3 meaning is a fine one. By contrast, Gray J set out the real distinguishing features of the two levels of meaning in Jamil versus Times newspapers, in terms which were cited without disapproval by Simon L.J. in Jamil versus Wall Street Journal and by Sedley L.J. in Jamil versus Times Newspapers Limited on appeal from Gray J's ruling. Moreover, judges should be wary of ruling out a meaning unless there is sound reason to do so. Example, where the scope of a defense of justification depends on it, and it is desirable to control the evidence which may properly be adduced at trial. Meaning and the repetition rule. It is important to note the particular role that the repetition rule may play in ruling out a pleaded meaning, even when the meaning may not be perverse. The repetition rule is a rule of law designed to prevent a jury from deciding that a particular class of publication conveying rumor, hearsay, or repetition of an allegation is true or alternatively carries some lesser meaning than the original allegation would bear. If a defendant endorses or repeats a defamatory allegation made by a third party, he cannot be heard to say that his words bear some lesser meaning than that borne by the words which he is repeating. The repetition rule thus necessarily circumscribes the considerable latitude a jury otherwise has in relation to ascribing a meaning or meanings to defamatory words where it so operates. It might be more accurate to describe the role of the judge in delimiting the possible meaning as not so much preempting perversity as precluding an otherwise possible meaning through the implementation of a rule of public policy. It may not be perverse to ascribe to a particular article the meaning A said that B murdered C. It is nonetheless not permitted to plead as a locus box meaning for the reason that the defendant is required. If choosing to justify to plead and prove that B murdered C, it is difficult to predict with confidence what problems for the ascertainment of meaning will flow from the decision of the Court of Appeal in Kyrgyzstan versus Times newspaper. In Kyrgyzstan, the court decided that where part of an article is privileged as a report of proceedings in Parliament and part is not, the meaning of the privileged part is to be determined on a different basis from the meaning of the remainder, in that so far as the privileged words are concerned, the repetition rule is to be disapplied. In consequence, the reported allegations will be treated as meaning only that the allegation has been made, not that the matter alleged is true. The iconoclastic approach in determining meaning will only apply if, which may not be known until trial, the plea of privilege is upheld. If, for instance, the words for which privilege is claimed are ultimately held not to be a fair and accurate report, then no special rule will be applied to determine their meaning. It seems likely, therefore, that in such a case, there would be little advantage in determining meaning until the issue of privilege has been conceded or argued out. In a case where there is also a substantial plea of justification, which depends for its tenability, as it usually will, on the chase level of meaning borne by the words, the consequence may well be that there will be no way of limiting the scope of the plea or of the disclosure which comes in its wake until after the issue of privilege has been decided. If so, the cost implications are likely to be alarming. Meaning and preliminary issue. A number of decisions on meaning have recently A number of decisions on meaning have recently been determined on applications for the trial of a preliminary issue rather than for a ruling under CPR PD 53, para 41. On the hearing of a preliminary issue, the judge is determining the actual single meaning of the words, not delimiting the meanings which the words are capable of bearing. As for the approach to be adopted, it appears to me to be particularly important where, as here, a judge is providing written reasons for his conclusions as to the meaning to be attributed to the words sued upon, that he should not fall into the trap of conducting an over-elaborate analysis of the various passages relied on by the respective protagonists. The parties are entitled to a reasoned judgment, but that does not mean that the court should overlook the fact that it is ultimately a question of the meaning which would be put on the words by the ordinary reason of the reader. The exercise is eventually one of ascertaining the broad impression made on the hypothetical reader by the words taken as a whole. Okay. Jurisdiction. The jurisdiction under CPR PD 53, para 4(1) is not limited to rulings on meaning pleaded in the particulars of claim. Either party may apply for an order determining whether the words complained of are capable of bearing a meaning attributed to them in a statement of case, para 4.11. That wording is wide enough to embrace a ruling as to whether the words complained of are capable of bearing a particular Lucas box meaning pleaded in the defense, and a ruling on the meaning pleaded by the party making the application. Appeal, except in cases which are clearly fit for argument. In that court, the Court of Appeal discourages appeals from rulings on meaning. However, it will be less reluctant to interfere with the judge's decision where the judge has ruled out a meaning once and for all, and where the judge has erred on the side of unnecessary restrictions of meaning. And even where the judge has upheld a meaning rather than ruled it out, it will intervene in a proper case. No self-denying ordinance can absolve this court from its responsibility to act in such cases. It is particularly willing to look again at exclusionary rulings by first instance judges on the blood frontier level between level 2 and level 3 meaning. Procedure. Until the introduction of the CPR, applications for a ruling on meaning were listed before the judge in charge of the jury list because the original wording of the rule required applications to be made to the judge in chambers and because the function of the rule was to bring forward the determination of an issue which was otherwise for the trial judge to decide. On the face of paragraph 4.1 of the CPR PD, it appears to be open to an applicant to apply either to the matter or to the master or the judge, but that cannot have been intended since the ruling is a substantive one which binds the trial judge. The practice, therefore, is to list applications for a ruling on meaning before the judge in charge of the jury list. However, applications to strike out on the CPR R342 may be made to the master. Applications for ruling on meaning should be made promptly after the service of the relevant statement of case. Following a ruling on meaning, where it is held that the words are incapable of bearing the meaning or meanings attributed to them, the court may exercise its power to strike out the pleading under CPR R3.4 or may, if appropriate, where there is a case to be salvaged, give the respondent the opportunity to re-plead. This summary disposal and summary judgment. This section is concerned with both the routes by which a defamation claim or issue may be disposed of summarily. These are, first, the procedure introduced by the Defamation Act 1996 for the summary disposal of defamation claims, under which the court is empowered at any stage of the proceedings to consider the strength of the claim and the defenses raised and to dispose of the claim summarily in favor of either party. Thus, the claim may be dismissed or the claimant may obtain judgment and be granted relief, including damages without a trial. The second route employs the summary judgment provisions of CPR Point 24, which make summary procedure available to both claimant and defendant in defamation cases. Despite an early preference for the summary disposal procedure, it is the summary judgment route which is now generally employed, notwithstanding the constraints imposed by the continuing, if in practice, somewhat emasculated right to jury trial. Okay, summary disposal under the Defamation Act 1996, origins and purpose of the Defamation Act procedure. The genesis of the new procedure was a bill drafted on his own initiative by Lord Hoffman and sent to the Lord Chancellor in 1989. The bill provided a person libeled with a means of clearing his reputation quickly and a defendant who had inadvertently published defamatory matter with a route by which a costly gold-digging claim could be avoided. The suggested bill did not obtain the support of the Neal Committee, which raised various objections to its proposals. It was said in particular that there was not a significant number of trivial libels fit for summary disposal and that a new defense of offer of amends would deal with the problem of newspapers confronted by a gold-digging plaintiff seeking to exploit a publishing error by the defendant. However, Lord Hoffman's proposals were in broad measure included in the draft defamation bill issued by the Lord Chancellor's Department for consultation in July 1995. In the introduction to the draft bill, it was stated that the new summary procedure was one of the most innovative parts of the bill's package of reforms. It not only brought defamation into line with most other proceedings, though by the time it was brought into force, this had already been achieved by CPR Point 24, but created an entirely new regime under which every defamation action must come before the judge at an early stage so that he can decide if the claim is suitable for summary disposal. Whether or not the parties have asked him to do so. Let's read that again. So, what was created is an entirely new regime under which every defamation action must come before the judge at an early stage so that he can decide if the claim is suitable for summary disposal, whether or not the parties have asked him to do so. The provisions relating to summary procedure, with some differences in wording, formed part of the defamation bill, and they were enacted without amendment. Dismissal of claim. Under the summary disposal procedure, the court may dismiss the claim if it appears that it has no realistic prospect of success and there's no reason why it should be tried. In the exercise of this jurisdiction, the court has dismissed one claim on the grounds that the words complained of did not bear a defamatory meaning, and another on the grounds that the claimant had no reasonable prospect of establishing malice in reply to a defense of qualified privilege. In yet another, court decided that the claimants had no reasonable prospect of establishing that there were persons within the jurisdiction who would either have read the words complained of published in a German magazine with a small English circulation or would have understood the words to refer to them. A court might conclude that the claim has no reasonable prospects of success because of the strength or merits of a defense. Judgment for claimant. The court may give judgment for the claimant and grant him summary relief if it appears that there is no defense to the claim which has a realistic prospect of success and that there is no other reason why the claim should be tried. Claimant's applications under the summary disposal regime have been rare. Defendant's applications. In the first years of the new procedure, it was much more frequently the defendant who applied for summary disposal. Sometimes in order to have the claim dismissed, but as often to compel the claimant to have his claim determined under the summary procedure rather than by full jury trial in accordance with the policy underlying this part of the 1996 Act, namely to ensure that suitable libel actions are inexpensively and speedily disposed of. In such a case, the court must be satisfied that summary relief will adequately compensate the claimant for the wrong which he has suffered. A defendant can indeed probably must waive an otherwise tenable defense to enable the court to grant a claimant summary relief. More recently, the summary disposal process seems to have fallen out of fashion with defendants, for whom the current practice is to apply for summary judgment under CPR Point 24 and, if appropriate, for determination of meaning under CPR PD 53 paragraph 4.1 and or to strike out under CPR Point 3.42 realistic prospect of success. The test to be applied in the assessment of the strength or weakness of a claim and defense is the same, namely existence or absence of realistic prospect of success. This phrase has become familiar not just in the summary judgment context, but in other areas also. It has also been accepted that the test under Section 8 of the Defamation Act 1996 is the same as that under CPR Point 24. Thus, the explanations of Lord Wolfe MR in Swain versus Hillman as to the meaning of no real prospect and as to the circumstances when the summary procedure should be employed offer material guidance. He said that the words no real prospect of succeeding do not need any amplification, they speak for themselves. The word real distinguishes fanciful prospects of success. The words no real prospect of succeeding direct the court to the need to see whether there is a realistic as opposed to a fanciful prospect of success. A party resisting an application for summary judgment has to have a case which is better than merely arguable. Reasons why the claim should be tried. The matters which the court shall have regard to in considering whether the claim should be tried and not disposed of summarily are 1. Whether all the persons who are or might be defendants in respect of the publication complained of are before the court. 2. Whether summary disposal of the claim against another defendant would be inappropriate. 3. The extent to which there is a conflict of evidence. 4. The seriousness of the alleged wrong as regards the content of the statement and the extent of publication. And 5. Whether it is justifiable in the circumstances to proceed to a full trial. It follows that claims against two or more defendants or possible defendants are unlikely to be the subject of summary disposal unless all defendants are before the court and not, example, beyond the jurisdiction or not as yet served with proceedings, and it is appropriate so to dispose of the proceedings against all of them. Nor would cases where there is an acute conflict of evidence usually be regarded as suitable for summary disposal, at least where the conflict relates to issues which are critical or important to the determination of the claim or defense. Moreover, the court will be cautious about ordering summary disposal where the claimant sues on foreign publication and relies on the presumption of the identity of English and foreign law, where issues of law are raised which arise from a developing area of jurisprudence and where Article 10 ECHR is engaged, and summary disposal would interfere with journalists' rights to freedom of expression. The Act would appear to accept that in some cases the imputations complained of may be of such gravity or have achieved such notoriety that a trial which is attendant publicity is necessary, even though the defense to the claim has no realistic prospect of success. Trivial or petty claims, however, are likely to be a target for summary disposal. Time for application. The Act enabled provision to be made by rules of court authorizing a party to apply for summary disposal at any stage of the proceedings, and by CPR PD 53 paragraph 5.2 an application can be made at any time after the service of particulars of claim. Thus, an attempt to obtain summary disposal may be launched well before there has been a disclosure of documents or exchange of witness statements, and the party faced with such an application will have to consider whether he should seek an adjournment on the grounds that discovery might elicit information necessary for precise evaluation of the merits of the claim or defense. It is submitted that though the court will have to consider an early application for summary relief on the material before it, it will also wish to be satisfied that evidence is unlikely to emerge which will crucially affect the claimant's prospects of success or the defendant's prospects of successfully defending.